Former President Donald Trump asked the Supreme Court to weigh his appeal of a lower court decision that he is not immune from criminal prosecution, a request that could further delay his 2020 election interference case. Trump's formal appeal serves as a pause on what would be a pivotal criminal trial for Trump while the Supreme Court deliberates on his request. The U.S. Appeals Court for the D.C. Circuit, which ruled 3-0 against Trump's presidential immunity claims, set the short deadline for Trump to appeal. While there is no timetable for the High Court to act, Special Counsel Jack Smith has pushed for a trial to take place before the November presidential election, where Trump and President Joe Biden are likely to face off again 4 years after they came head-to-head in the 2020 election. The Supreme Court's options could include rejecting Trump's emergency appeal, which would allow U.S. District Judge Tanya Chutkan to restart the trial proceedings in Washington's federal court. The trial was initially slated to begin in early March. Justices on the High Court could also extend the delay while they hear arguments on the immunity dispute. Given the unprecedented nature of the request, some legal experts have suggested the Supreme Court may not want to give the appeals court the last word over the dispute, even if the 9-member bench ultimately comes to a similar conclusion on Trump's presidential immunity argument. If the Supreme Court does take up the case, the oral argument schedule set by the justices could determine how soon the trial could begin, if they agree with the appeals court's finding that he isn't immune.